What a joy it is to see so many people here from the legal community, and thank you for coming out tonight on this absolutely gorgeous October evening. Honorable Judge Heather Morse will come up and say a few words. We want to welcome Judge Morse. She was a very active member of Santa Cruz Women Lawyers Association and also was on the California Judicial Council from 2003 to 2005. Judge Morse?
I'm honored to have a moment to speak with you about the upcoming dedication of this beautiful new podium that is going to be dedicated in honor of Judge Akau. It will be donated to the court to commemorate the many contributions that Judge Akau gave to our court in her 11 years of service to the Santa Cruz Superior Court. When I was appointed in 1989, I had many wonderful male colleagues. But when Judge Akau won her historic election in 1994, she became a wonderful woman colleague that was so talented and added so much diversity and perspective to our bench. I really think that it was just an amazing addition to our Superior Court. And so Judge Akau was an accomplished jurist in many areas. She loved every assignment that she had in the court. She did criminal, she did drug court, she did collaborative courts. She also did court administration and enjoyed that quite a bit. But she is especially remembered for her service in the area of family and juvenile cases, where she felt she was most able to make a difference in the lives of children and families in Santa Cruz County. Her work with juvenile dependents and delinquents assisted Santa Cruz County, if you will, at being a leader, a national leader in new approaches to juvenile justice. Judge Akau would be honored that we spoke of her today and her accomplishments, but she'd also be more honored that this gorgeous new lectern, and I say lectern, we've had a discussion whether this was a lectern or a podium, but this gorgeous new lectern will have a historic and honorable initiation by our wonderful new Chief Justice as she utilizes it today to give her address to the Santa Cruz legal community. Thank you very much.
Chief Justice TANI CANTIL-SAKAUYE began her studies at Sacramento City College before earning her degree at UC Davis, graduating with honors. And after taking a year to live in the Philippines, she then attended law school at UC Davis. As a new attorney, she worked at the Deputy District Attorney in Sacramento and served on Governor George Deukmejian's senior staff as both a Deputy Legal Affairs Secretary and a Deputy Legislative Secretary. While sitting on the Superior Court, then Judge CANTIL-SAKAUYE established and presided over the first Sacramento court dedicated solely to domestic violence issues and was later able to rely on this experience when she served on the Judicial Council's Domestic Violence Practice and Procedure Task Force, chairing its Best Practices Subcommittee. She has also been a member of the California Commission for Impartial Courts and has served as president of the Anthony M. Kennedy American Inn of Court, an organization dedicated to promoting civility, ethics, and professionalism in the practice of law. In fact, by the time that Chief Justice Ron George appointed then Justice CANTIL-SAKAUYE to the Judicial Council in 2008, she had already served over 20 years on the bench at both the trial and the appellate level. 2 years later, when Governor Schwarzenegger nominated her to the Supreme Court in July 2010, the Jenny Commission rated her exceptionally well qualified, and she was then unanimously confirmed by the Commission on Judicial Appointments, winning an overwhelming majority of votes in November's general election that year. And she now chairs the Judicial Council of California and the Commission of Judicial Appointments. Tani Gore CANTIL-SAKAUYE, got to throw in one more last name there.
My mother would be happy.
Your mother would be happy. Was sworn into office as Chief Justice of the California Supreme Court this past January, and is the first Asian, Filipina American, and the second woman to serve as California's Chief Justice. And as a reminder, yesterday marked California's 100th anniversary of the woman's right to vote. And tonight, our guest speaker, the Chief Justice of California Supreme Court, is clearly a woman. So what a long road many Californians traveled to get to this point. To help underscore the historic achievement of the women's right to vote, women lawyers invited the Chief Justice to come to Santa Cruz, and she was kind enough to accept. We believe that Chief Justice is a great reminder of the kind of strength that a woman must carry in order to gain equal footing in important places. As many of you may remember, Assemblymember Calderon first described the Chief Justice as nice, smart, and attractive, but then complained that these same characteristics were not enough to become a good Chief Justice. However, what he didn't realize was that she's also fierce, fiery, and a fighter, which is why despite her good looks and niceness, she sailed through the nomination process, crushed the confirmation hearings, and cleaned up the votes at the November election, all without having to reduce herself down to mean, dumb, or ugly. Chief Justice TANI CANTIL-SAKAUYE brings to life the "we can do it" icon of Rosie the Riveter, which, as some of you may know by now because I couldn't keep it quiet, is what she's going to dress up for as Halloween this October. Married to Mark Sakauye, a retired police lieutenant, they have 2 daughters. Please help me welcome to the stage Chief Justice CANTIL-SAKAUYE.
Well, thank you, Dinah, not only for that warm introduction, but for inviting me to be here tonight. It's a pleasure to be here, to join you in this intimate, collective environment to talk to you and to answer any questions. But first, I do want to do the honor of being here to pay homage to this lectern, because I understand that it is in honor of Judge Akau, the first female Asian judge in this county. And I understand how important it is to be the first in many things, but definitely not to be the last, so that people who follow after the first have different challenges from the first. And so it is an honor to be here to stand in front of you all behind this lectern. It's also important for me to extend my thanks not only to the Women Lawyers Association of Santa Cruz, but also the Bar Association of Santa Cruz for sponsoring this event and inviting me, and also for Monterey for coming this far, for San Jose. I know the Monterey County Bar Association and Women Lawyers Association is represented here, and I'm grateful to you for coming out tonight on such a beautiful evening. I also want to take this time to recognize folks who have always been by my side, who give me great information and counsel. And if there's not a question here that I can answer tonight, they can. And so I'd like to ask to stand, please, our interim acting administrative director, that is Ron Overholt. Someone you love and I love. Not that we don't love Ron, but I'm only saying only because Chris is from Santa Cruz. I want to also the Chief Deputy, Chris Patton. And as you know, Chris moved from a Bancro Regional Director, came to the spot of Chief Deputy, and taking Chris's spot at Bancro is Althea Lowe Thomas, also here tonight. And since this is my first opportunity to address you, I also wanted to pay respects to many firsts here. In Santa Cruz County, I'd like to pay my respects to Judge Heather Morse, the first female judge to the Santa Cruz County bench, and also the first female presiding judge. And also because firsts have a way of helping others become firsts, I also think it's important to recognize that Judge Grover, and I'm not sure she's here yet, from Monterey County, also the first female presiding judge of that county. You know, Dinah, it has been 100 years in order to commemorate the vote, but it's also interesting to note that in 100 years we now have a female majority on the California Supreme Court. And we also know that based on our numbers, near as we can tell from our latest count, that women make up 30% of the judicial branch bench as judges. We also know that more women are coming out of law schools in greater majorities than ever before. And I'm told, I can't say that this is evidence that I've seen, but I'm told anecdotally that women pass the bar at a rate higher than men, according to the state bar. So it's important that in 100 years we've been working very hard. But I do want to open up my remarks tonight by telling you that in the last 10 months, what's clear to me is my role as Chief Justice of California has sort of settled itself into 3 roles. I find that the 3 roles of Chief Justice of California are Chief Justice of the California Supreme Court, and that is in its most traditional role of deciding cases, resolving conflict, working with my 6 very talented and elegant, eloquent brethren on the California Supreme Court. The second role that's played by the Chief Justice of California is also one that probably is not as well known, but in this particular year, just as active, and that is Chair of the Judicial Council. As many of you know, the Judicial Council is the policy-making body of the judicial branch. So when you think about the judicial branch and you think about the 58 superior courts and the 6 courts of appeal and the 1 Supreme Court, as a whole, we are a branch, the third co-equal branch of government. And in order to make decisions for that branch as a whole statewide on policy, the Constitution has permitted and provides for the creation of the Judicial Council, which is a 31-member body, 21 voting, 10 advisory. It's made up of judges, lawyers, justices, and court staff. It's also interesting to note that the judicial branch, when the Judicial Council was created and the Administrative Office of the Courts was created, that the Judicial Council amendment to the Constitution was sponsored by the legislative branch. 2 senators from California said basically on the ballot argument when the Judicial Council was created that in California, when there's a problem in the courts, it's nobody's business. And when a procedural rule doesn't work in California, it appears to be nobody's business. So with the creation of a council, when something is not working statewide, it becomes Judicial Council's business to correct the problem for the public, for the litigants, and the parties. And so the Judicial Council exists to primarily serve the public, but also to serve the courts. And because all of us in the branch have day jobs, every single one of us, we can't do the work of the staff. And so staff work is now under the hands of the Administrative Office of the Courts. That's the second hat that the Chief Justice wears as his or her role of Chief Justice of California. The third role or category that I found for the work and responsibilities I faced in the last 10 months is that as the Chief Justice of the Judicial Branch. And that is where I act in the capacity as the leader of the branch. Now, I'm not quite comfortable with that yet, but I know that the picture is this. When you think of the executive branch, you think of the governor. When you think of the legislative branch, you think of the Senate President, Darrell Steinberg, and you might think of the Assembly Speaker, John Perez. So then when you get to the judicial branch, you think, well, who's the head of the judicial branch? And so now, in the last 10 months, as I've gotten used to this, it is me instead of Ron George. So it is in that capacity, as head of the judicial branch, that I wanted to direct my remarks to you before it is I take your questions to me. And so it is as head of the judicial branch that I've gone up and down the state in the last 10 months in my spare time, trying to hear from you, the lawyers, the people who are in the trenches. I'm trying to hear from you what it is that you think works, what it is you think goes wrong, and what the remedies are. And so as I've gone up and down the state, and mind you, as diverse as this state is, courts where there are 11 judges, courts where there are 70, courts where there are 600 judges, it is a task because every court has its own culture, and every county is really doing it the best that they think they can at that time. So I'm telling you, as chief and as head of the judicial branch, I've had a dialogue with you. And what I found confirms what I know, and that is that this branch and this bench and this bar is the most talented. The people who bring ideas to me, who volunteer time, who work toward a solution, have been just absolutely necessary and critical to what I do. For example, because of the budget, which affects all of us, I've had the opportunity to meet with lawyers from Northern California, lawyers from Southern California, and I'm now looking to meet with lawyers from Central California, forming a coalition with the State Bar as staff, with assistance from the AOC, to find a way that we can coalition build and go to the legislature to convince the legislature that enough is enough. There can be no further cuts to this judicial branch budget without jeopardizing and marginalizing civil rights. And so this group of attorneys have volunteered their time to go to the Capitol, to work together, to put forth that idea to legislators and to the governor. And really, when you think about it, the bench has no influence in the legislature because we don't bring votes, we don't bring campaign funds, and we don't bring promises. Our promise as judges is we will follow the rule of law. We will rely on history, precedent, and stare decisis in order to make our decisions. But that gives us very little sway in the legislature. And so with the attorney voices that represent the public and the face of the public, we hope that in fiscal year 11-12 and 12-13, we'll be able to staunch the cuts and seek restoration. And it's the attorneys and the AOC and the State Bar that, with some help from the branch, have come together with a plan, a 3-year plan to restore the budget to where it can be adequately funded for the public in the next several years. But as head of the judicial branch, our role has not been only to address budget, because we are so much more than that, because we are still moving forward. I'd like a show of hands of how many lawyers here have practiced more than 14 years. Quite a few of you. How many have you practiced more than 20 years? Quite a few of you. So many of you will agree with me that when I joined the bench and when Judge Morse joined the bench 21 years ago, the branch was a different place. Because in those days, trial courts were funded by the county. Because when I was on Muni Court and I needed new sofa for my chambers, we went across to the County Board of Supervisors and received an okay for the money, because in those days, the judicial branch budget for trial courts was under county control. And we used to joke, at least in Sacramento, that the county budget for trial courts was right below sanitation. And so we were like any other county entity, except that we were a judicial third branch of government. And so that is only one aspect of what triggered the 3 game-changing events in the judicial branch. State trial court funding, which you know in 1997, was taken over by the state, and the counties were relieved of that responsibility. And what that meant was more consistent programs, more consistent funding, raised the boat for every county, and provided accessibility and accountability. And it created new programs as a result of more uniform access to money, like the self-help programs, like the jury reforms. And a year later, as you know, Muni courts unified with superior courts. And so in those days, we had 220 courts, and they unified by choice into 58 trial courts. So for example, as many of you know, when you went to court, there were two clerks, a Muni court clerk and a superior court clerk. And there were 2 HRs, a Muni court HR and a superior court HR. But with the advent of unification, we took those 2 courts, we merged them into a greater, more efficient, more well-rounded entity with fewer people. And so we saved money and we created efficiencies. And we created predictability for the lawyers and less confusion for the public. And then in 2002, we thought, we are a third branch of government. We need to repair our courts. We need to be responsible for that. And so in 2002, we achieved the right to own, repair, and modify our court buildings. And I submit to you that it is these 3 changes that have permitted us to weather the financial cuts that we've taken in the last 3 years. It's those things that have allowed us to stand as an institution, to stand strong in California's problems in the last 3 budget years. But it's also that institution that's already built that permits us to look forward, that permits us to make other changes that accommodate the needs of the public and the lawyers who practice in the courts, and to make life easier for the judges, because judges work under a crushing caseload. And so, even though we have budget concerns, we are still a strong institution, and we still have the momentum and the impetus and the talent to go forward with additional changes. And so, even though budget has occupied most of my 10 months, and most of Ron Overholt's 10 months, and most of Chris Patton's 10 months, and probably all of Presiding Judge Almquist's 10 months, I would only point out that we are still moving forward. And the first thing we did was I instituted a change in leadership in the Judicial Council so that we would have fresh blood, new voices, new people to come forward with different ideas. It's so important that the conversations stay fresh and stay current. And it means you need an influx and exflux of people in that conversation. And so I've created and appointed new leadership and brought into committees. Also because I do not know whether or not the AOC completely and fully serves the trial courts and the public and the Judicial Council as staff, I have asked and created an evaluation commission that will assess the AOC and determine whether or not we are doing the best we can with the resources we have in serving the public, the courts, and Judicial Council. And that's a committee made up of entirely of judges and retired judges and justices and a few attorneys and some state executives who are retired who in their day made the trains run on time. And they're taking a look at how we operate. The AOC has never been reviewed in this way, but we've never had an opportunity really to reassess how we move forward and our old values and our foundation. Also, I've created another committee to look at our construction program. As you know, in 2002 and in 2005, we received authorization for $6.5 billion to repair ourselves, to fix our 19 million square feet of real estate that we own. And like any good investment, it needs to be repaired and maintained for the safety of litigants and families and children and judges and the public. And so it's a lot of money, it's a lot of responsibility. And so we've put judges in charge of those folks and those experts who are moving the project forward. The judges who can provide oversight and recommendations to the Judicial Council to make sure that we're being prudent and wise about the use of that money in the future under these circumstances. I've also created a committee of judges to seek oversight and review and make recommendations on the case management system. Because like it or not, at some point, California is going to have to move into the electronic age. At some point, the branch is going to be there. I hope in my tenure that that happens, and I'll be working very hard to do that. But I will also promise you that it will not be a shove into the 21st century. It will be a coaxing into the 21st century. Coaxing by example and temptation to try a new system that might work, because I fully believe in the motto of being online, not in line. And lastly, I would say, notwithstanding these changes and these assessments and our concerns with the budget, it's clear to me that we need to engage the public, because it is the public who doesn't understand us. It is the public who decides whether or not, through legislative work, whether or not the judicial branch should be cut, whether or not they understand us or not. And so I've created a commission of education folks to move forward to find the best way to convey this information. And we hope to eventually scrape together the funds through grants to have a summit on the best possible way to bring education to the schools, to the public. But many times that is best done by you. When you speak to Rotary clubs, when you speak to schools, when you go out to high schools, when you speak to the Scouts, that's the best word of mouth, when they can put a face to the judicial system for which they know very little. So the last 10 months has been quite a ride. It's only been 10 months, but I like to say we've done a lot of living in 10 months. We've done a lot of learning in 10 months. And we will continue to do so. Every year will be the same, I believe, in part because so much of our work interfaces with the legislature. And the legislature, as you know, has fewer and fewer lawyers, fewer and fewer practicing lawyers. So when change comes or cuts come to the judicial branch, there's not really a fundamental understanding of how that impacts the public, because lawyers aren't there in the leadership to be able to say how this will affect litigants. So we have that job. And I ask you, as I've asked every lawyer group up and down the state, for your assistance to make sure that if you can, join Bench Bar, the organization that lobbies the legislature a couple of times a year, educates them on the branch, and points out specific bills of interest to the branch that are generally accepted, such as funding. Because we need to be a constant voice in the legislature, and that brings me full circle to say that it is through groups like yours that we are able to make change, through dialogue and transparency and communication. I also want to say one more thing before I take any questions, And that is, I had the privilege today of meeting with the Santa Cruz Superior Court before I came here to join you. And if you don't know this already, you should know that the Santa Cruz Superior Court is an example, one of the best run courts that I've seen in this state. I know that 3 years ago, they heeded the warning of the onslaught of the budget crisis. And instead of waiting around for someone else to solve their problems, instead of looking for a handout, these good judges and these good staff members and the administration got to work, and they made sacrifices. And those weren't easy. And first they had to educate themselves, because I'll tell you, not many judges look at a budget. Not many folks look at a budget unless they have to. And when they did and they saw their options, they immediately got to work, and they built relationships amongst themselves, and they talked to the point where they are strong 3 years later. They are sound 3 years later. We expect in the Judicial Council to be hearing from other courts requesting certain bailouts in the next several years, well, next several months for the next several years. And we don't anticipate Santa Cruz to be one of those because of their good stewardship, their strong relationship with each other. And really, when you think about the bottom line of what Santa Cruz has done, they've served the public in the best possible way by making sure the court system stays open and is sound and available for those most in need, so that you can come to court relying that your Santa Cruz court is going to be there for you, because they took planning on themselves and took their leadership and talent and crafted a solution. So it's a pleasure to be here for many reasons, and I salute Santa Cruz Superior Court. I'm happy to take any questions you may have. This is the overall picture of a case once it's been through appellate review. So say, for example, it's a civil case, you're the defendant, or your client's the defendant, and the trial court found in favor of the plaintiff, went on appeal to the Court of Appeal. The Court of Appeal also affirmed, so they found for the plaintiff. And now the defendant wishes to exercise the privilege of petitioning for review in the California Supreme Court. So the petition's prepared and sent to the California Supreme Court. What happens then is, for all cases from the Court of Appeal that come to the court by way of petition for review, and so let me back up and say, all cases are heard at the trial court level with few exceptions. All cases may be appealed with some exceptions. Misdemeanors cannot be appealed. But most cases, generally speaking, may be appealed to the Court of Appeal as a matter of right. But that's usually where it stops, because by the time you get to the Supreme Court, you don't have a matter of right to have a case heard in the Supreme Court unless it's a death penalty case. So in order to have your case heard by the California Supreme Court, you have to petition the court for review of your case. And the court will grant review under two circumstances. One, if there's a conflict in the law in the Court of Appeal level. So there are 6 courts of appeal, and if there's a conflict, meaning different cases are conflicting with a rule of law, then the Supreme Court is more likely to grant review of your case if it provides the right vehicle to resolve the conflict in the Court of Appeal. The other ground upon which the Supreme Court will grant review of a matter is if it is of such statewide importance that the state needs the California Supreme Court to speak on the issue. And then that's another way that a case will be granted review. So a case comes in, petition for review is filed. What happens with that case is it goes to one of 3 places. Well, one of 2 places. If it's a civil case, it goes to Civil Central Staff, which is a group of attorneys. Or it also may go, if it's criminal, to Criminal Central Staff. So the Supreme Court has at least 2 central staffs. And what happens is these central staffs triage the case. So say it's a civil matter, it comes into Civil Central Staff, and an attorney will look at the case and put it in order of procedure, facts, holding, and trial court impact. And then that piece of paper, which is a conference memo, will then be compiled with all of the other petitions for review for that week. And every justice on the Supreme Court gets that stack. So for example, tomorrow is Wednesday. Every Wednesday we have petition for review. conference. So tomorrow, all of us justices will sit around the table. We've all read every petition conference for review, and we vote whether or not that case should be granted review. And we vote in seniority. So I'm the chief, and I sit at the head of the table, but I vote last. And I am the scribe. I record everyone's votes officially. So once the petition conference comes up, say your case is number 7. I call number 7. I turn to Justice Kennard, who's the most senior justice, and I say, how do you vote? And she says her vote, I record it. Grant, deny, join 3 to grant. I then next move to Justice Baxter. I record his vote. Of course, the vote is not just a vote, it's comments as well, but I ultimately record the vote. I take a little side note of the comments, and I'll tell you why in a little bit. Then I move to Justice Werdiger, record her vote. Then we cross the table, and I move to Justice Chin, I record his vote. Then I record Justice Corrigan's vote, and then Justice Liu's vote, and then I vote. Now, if we get 4 votes to grant, we accept the case, and it will then be on our docket. And then it's up to the Chief Justice to assign the case to one of the justices for writing a draft opinion. And so I will look at the comments that were made, find out who cares the most, and then consider assigning that case to that justice to write up the draft opinion or the draft memo that will circulate amongst all the justices. So once the petition for review is granted, then the parties are mailed notice, and they're told what the issue is. You might have proffered 3 issues. We may reject all of them and tell you our own issue. We may say we only want 1 issue. I suppose you might have heard that before. But keep in mind, of course, that the central staffs see law developing. And sometimes there are cases that come up that we would like to grant review, but it's not the right vehicle. The facts aren't good. They're messy. There's something missing. So that's not the case. So Civil Central staff sometimes knows we're looking for the right vehicle for a certain issue. And then sometimes they'll say, this is the vehicle. It would be good for this issue. And so we will then grant review on the issue that we think needs to be addressed based on what we've seen as the flow or the wave of the cases that have been coming in. So once the petition for review is granted and the issue is isolated, then the parties will brief that issue. And once it's fully briefed, a memo will be prepared, a draft memo, which will then be circulated simultaneously to all of the justices. So we will each have in our hands the draft memo of the case, which sets out the facts and the circumstances and some tentative legal conclusions. Now, every justice has on his or her chamber staff 5 attorneys. And the attorneys will get the draft first, and they will make a little analysis of it, whether they think something is strong or weak, and then all the documents come to the justice. My attorney's calendar analysis, the calendar itself, the petition for review memo, and the Court of Appeal opinion. And I will read through that and decide whether or not I agree, disagree, have doubt, have reservations, etc. And then I will, on a separate sheet of paper, write how I feel about the opinion, whether I concur with reservations, disagree, or doubt. And all the justices will turn in that form of paper to the clerk's office, and the clerk's office or the calendaring clerk's office will keep track of those. I get all of those votes, as do all of the other justices. And so when we get 4 concurrences, then we believe the matter is ready to be set for oral argument. And as you know, we have to give by law 20 to 30 days notice before a matter is going to be calendared for oral argument. And at oral argument, the draft is tentative. And many times after argument, the draft changes radically based on information or more fleshing out of issues after oral argument. The way we track all of the cases is we use a lot of different colored paper, and the color means something. And I'm still looking at color and saying, goldenrod? So we keep a track of the blue list. Is a list of all the cases circulating in the Supreme Court. The salmon sheet is a list of all the cases circulating but have been argued. So the 90-day clock is ticking on the salmon sheet. But the blue sheet is the list of everything else, and it's the list of concur, disagree, etc. So we keep lists of everything, and we review them every Wednesday at conference. I'm not permitted to talk about any pending cases or impending cases. The timelines don't kick in for the court until really the case has been argued. Once a case has been argued, you always hear me say, or even any presiding justice of a court of appeal, as Rich McAdams will tell you he no longer has to hear, is matter submitted. Those are magic words, because what they mean then is the 90-day clock is ticking. By law, matters submitted at the Court of Appeal and the Supreme Court have to be decided within 90 days of being submitted. Failure to have them decided, as any judge will tell you here, means you don't get your paycheck. And not only you, your bench doesn't get their paycheck. So there's great pressure for you, of course, to make sure that your matter is finished within the 90-day rule. After a case is argued, then once there is a tentative concurrence on how well, let me tell you, after a case is argued, we meet in my chamber. Right after lunch, we discuss the first 3 cases that were on calendar. Right after the afternoon, 2 or 3 cases, we meet again in the evening at my desk, at my conference table, and again, we sit in seniority and we speak in seniority as to how we feel about the current case and whether we are in agreement with the draft or not. And it's here where I take a number of notes, because that means there will be changes to the draft or not. But if there are not changes to the draft, then we might be looking at a concurring and a dissenting or a dissent. So this is where the justices start to tell you where they might be on the final opinion. And so once I have those notes taken, I'm tracking very carefully that this matter moves timely, so that if there is a dissent, the author has an opportunity to respond to the dissent in the majority opinion, which means we have to be careful about the 90-day rule. So we're very careful about, and we have internal rules that keep us on track for the 90 days. You say that when you file in the Court of Appeal, a brief goes to the Supreme Court. And I'm aware of that. I will tell you, we don't see it. We don't see it, and it must be kept in storage for later use if necessary. But we don't see it. And where that electronic copy goes, I will ask. I will ask. I frankly would like to see more electronic copies, because I think it's so much easier for the parties to prepare. It's easier for the courts to handle. If we had a trial court record that was digital, then it means that and I've heard this in certain instances, that the appellate review can be faster and can save time with an appellate record that's digital. And of course the same would be true of the Supreme Court as well. How the realignment law will affect us? Yeah. Well, it's in great flux now. And courts are, in this instance, each trying to figure out how it's going to respond to it. And I know that we have the regional directors working on putting together some forms that might help the courts deal with the many issues that we'll resolve. But this is a transition year for realignment. I would say next year as well. And what we know at the Supreme Court is, we know we probably won't see these issues for about 2 years, that they will go through the appellate court first before they get to us. We think there will be much change in the meantime. We also are trying to address many of the changes for the courts through seizure. But this is as you know, the realignment bill came very quickly to the legislature, passed in 48 hours, and had little input from the judicial branch. But we have a group of subject matter experts, judges from around the state, who are working to try to make it workable for the trial courts. It's too early for us to tell yet what the impact will be. Are there any particular electronic models that we support? Not really beyond our own developed and owned software, the CCMS system. But because the 58 trial courts have about, last number count, 125 different computer systems amongst the 58 courts. And I'll just give you an example, and I don't know that it's changed much. But when I was a trial court judge in Sacramento, and I was trying to sentence a person on a felony to 25 years, I would try to get all of his traffic tickets, all of his outstanding misdemeanors. I would try to clean up everything so he didn't have anything to worry about when he went off to prison. It's true. It's true. You'd be surprised. He'll plead to 25, but he wants that traffic ticket dismissed. And I know you know that. So the trouble is, my computer in criminal couldn't speak to the traffic computer. And when I wanted to find out what was going on with with a family law case where his children were involved, my computer didn't let me into that computer. So I'd have to continue his case 2 or 3 or 4 or 5 times until I get all the files together, clean all them up, and that's just what he knew about. There was certainly more out there. And I know that for a lot of courts, that's still the problem. And that's part and parcel of the fact that trial courts have authority and independence over their own court, as well they should. So the fact that we at Judicial Council, and I personally think that we have to move into the digital age, there's not a way that that can be forced upon trial courts. I look at places like Orange County, which you probably have heard this, their entire civil has gone paperless. They don't have a paper in their civil because they are on a version of the CCMS program that permits them to go paperless with electronic filing and case management. And they tell me that they had 22 people that they used to have in that unit handling the paperwork. What they were able to do is take those 22 people and put them in other parts of the court to better, more interesting, more engaging work. And so they too, like Santa Cruz, are really in a great place going into fiscal year 11-12 because they saw the problems, changed their business model into something more digital to where they could assist the public. And that's where the line comes from of being online, not inline. And as you know, CCPOR is built on the backbone of CCMS. So if you could take the benefits of CCPOR, which is the Protective Order Registry, if you can take that and imagine how helpful that would be statewide if, for example, there was only one probation report. You only have to write it, or the meat of it once. The defendant's background, his social history, his education, his record. Once that's in CCMS, then if that person comes before you in another county, you have the probation report. All you need to do is add to it if necessary. But you have a greater picture of the person. You have a greater picture of how they can be helped. You have a greater picture of what hasn't worked in the past. And you have a greater ability to clean things up if they end up going to prison for some period of time.
Women Lawyers of Santa Cruz County is so appreciative of you coming and speaking tonight that we are giving you an honorary 2012 membership in Women Lawyers of Santa Cruz County.